All right, so I'd like to call the meeting to order. It's March 1st, 7 p.m., East Lyme Inland Wetlands Agency meeting. Today we have Phyllis Berger, we have Doreen Ryan, I'm Kristen Chantrell, Sam Sims, Greg McIntyre. We have our Inland Wetlands agent, Gary Gaishel, and Sue Spang, our recording secretary. And from ex officio, we have Ann Cichello here today. We're going to start with the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. So first on our agenda, we have public delegations. Public delegations is the time when members of the public are invited to speak to the commission about certain matters, issues, or concerns related to approved wetland permits, and in-house proposals or general topics of discussion are open to comment. Agenda items, referrals, applications subject to a decision by the commission, a public hearing, or in litigation may not be discussed. Do we have anyone here today from the public that would like to speak to this? All right. No public hearings today. Next would be acceptance of minutes. The meeting minutes of February 1st, 2022 regular meeting. Do I hear a motion to approve or deny the meeting minutes?
I move that the meeting minutes be approved.
Thank you. Second?
Can I just ask a question? There was something from Gary's report about issuing a cease and desist order.
Yes.
Did you do that?
No.
Is there a reason?
The applicant applied for a permit.
Okay. Do we have that permit here?
Yes.
I know there was a permit to do additional work.
And this is for 297 Boston Post Road?
Right.
Yes, so they made an application to correct the violation.
Okay.
So rather than going forward with an order, I just figured the resolution was making application to permit the activity.
So does that application cover, the dirt going into Patagonia Lake?
Well, it's on
the fence?
It's on the agenda.
For discussion.
We'll go through it.
Right.
Okay. So does anyone second the acceptance of the minutes?
I'll second.
Okay, thanks. All those in favor?
All right.
I'm going to abstain because I wasn't here.
Okay.
Vote for my own motions.
All right, so next would be our ex officio report. Anne, would you be able to?
Hi.
Hi.
So basically, let me just think a minute. It's a long day. For the Board of Selectmen, we are right now going through the budgets, having quite a few meetings on that. And then the other issue I think I discussed last time was the ARP funds, and the subcommittee's been meeting weekly, and we will be presenting to the Board of Selectmen in another week or so. So that's pretty much what the Board of Selectmen has been involved in. Any questions?
What's the town doing with Amtrak and the fence that they're trying to,
That's a good question. So I know that the first selectman has been in discussions with Amtrak, and I think they are trying to propose a different fence than what Amtrak was suggesting. But I don't know where it's going from that. We have a meeting tomorrow, so I'll probably hear more about that tomorrow, and I can report next month on that. Or hopefully we'll have more details. But I know that a lot of the townspeople are not happy with what Amtrak is proposing, because you don't have a good view.
And just out of curiosity, there was a notice in the paper about the selectmen meeting regarding the cemetery that's I think it's probably near where the gas station is going, exit 75?
Yes.
What's the proposal for that? Are they going to move the cemetery?
No, they're not going to move it. It was, let me think a minute. Basically, all the people who were owners in the cemetery,
So is that project on the agenda tonight? That land that used to be a hotel or whatever it is over there on that exit?
I don't believe so.
75?
No.
Oh, okay. Because I've noticed the work has started there. They
In
cleared.
that cemetery, they have like very few, headstones, they're all kind of crumbling. But, I know that through the.
Yeah, it's kind of odd. A little bit further down the street on 95, there's another little area where there's
Exactly,
something
yeah.
strange.
Yeah.
Any other questions?
No, I don't think so. Thanks.
Sure.
All right, moving on to new business, land use 101. Attorney DeMarco, would you like to?
Good evening, folks. My name is Mark Zamarka. I'm with Waller, Smith & Palmer, the Town Attorney's Office. And as we do every so often, we have a presentation to our land use boards as to the basic duties, responsibilities, and obligations of serving on the Inland Wetlands Agency. Like any land use agency, the Wetlands Agency is a creation of statute and has only those powers that are granted to it by statutes and contained in the statutes and your regulations. The basic purpose of an inland wetlands agency is to supervise regulated activities. A regulated activity is defined in Section 2.1 of your regulations and in the statute as any operation within or the use of a wetland or watercourse involving removing or deposition of any material or any obstruction, construction, alteration, or pollution of wetlands or watercourses, excluding certain specified activities. Section 2.1 also defines what qualifies as a wetland or watercourse. Wetlands Agency performs 5 basic functions. It passes and amends regulations, it determines the boundaries of wetlands and watercourses, and maintains and amends maps of those. It passes on permits to conduct regulated activities, enforces wetlands regulations, and also at times reviews and makes advisory reports to other referring agencies such as the Zoning or Planning Commission. There are certain types of operations that are permitted as of right within a wetland or watercourse that do not require permits. These are found in Section 4.1 of your regulations. Won't go through them ad nauseum, but they do include certain specified agricultural uses, boat anchoring or moorage, uses incidental to the maintenance of residential property, and the construction and operation by water companies or municipal water supplies of dams, reservoirs, and other facilities. The jurisdiction of a wetlands agency is limited to regulated activities in wetlands or watercourses or operations which affect them as defined by the statute, such as alteration or pollution of wetlands or watercourses. You do have the authority to regulate outside of a wetland or watercourse in what is known as the upland review or buffer area. As you are probably aware, I know we do have some new members here. For many years, the upland review area was within 100 feet surrounding a wetland or watercourse. A couple of years ago, this agency amended that to 300 feet. I do believe that matter is still on appeal. You can regulate within the upland review area pursuant to statute when activities there are likely to impact or affect a wetland or watercourse. Now, the Supreme Court has held that you can regulate outside of wetlands and in the upland review area only activities that are likely to adversely affect the physical characteristics of those wetlands or watercourses. An effect just on the wildlife in that upland review area is not sufficient to allow you to regulate within that. It also has to affect the wetland or watercourse. Most of your time will probably be spent reviewing applications to conduct regulated activities. Now, again, we talked about what a regulated activity is. When an application comes before you, certain statutory timelines kick into effect. These are found in Section 8-7D of the Connecticut General Statutes. It's a little different for a wetlands agency than it is for a planning or zoning commission. You do not necessarily have to hold a public hearing. However, if a hearing is required or the agency decides to hold one, it has to be begun within 65 days from the receipt of the application, and once the hearing is opened, it has to be completed within 35 days. If a hearing is held, you have to have your decision rendered within 35 days after the close of the public hearing. If there is no hearing held, then an application has to be decided on within 65 days from the date of receipt. Now, generally under the statute, the date of receipt is considered the next regularly scheduled meeting of the agency, or 35 days after it was actually received in the land use office. Because the agency meets monthly, it's generally accepted that the date of receipt is the next regularly scheduled meeting. Now, there are 3 ways that a public hearing is required on an application. You can find that the proposed activity may have a significant impact on the wetlands. This is a determination, and this is a preliminary determination on your part, and what is defined as a significant impact is set forth in section 2.1, the definition section of your regulations. Another way that a public hearing is required is if a petition is signed by at least 25 people who are 18 or older and live in East Lyme and request a hearing, or 3, if you decide that a hearing is in the public interest. Wetlands applications are also a little different from planning and zoning in that if someone files an application with a planning or zoning commission and they do not render a decision within the statutory time frame, then that application is considered approved. That's what's known as inferred approval. It's sort of a trap door to make sure that the agency, that the specific commission, planning or zoning, acts within the statutory time frame. That does not apply to a wetlands agency. There is no inferred approval on an application to conduct regulated activities. The sole remedy under the statute is that if you fail to act within the time frame, the applicant can request a review by the Commissioner of DEEP. That rarely happens simply because it takes usually up to a year, if not more, and Lord knows how long now with the pandemic, for the matter to even be heard by DEP. Now, the public hearing is conducted before you. The applicant comes forward, they present their application. Experts, especially in matters before this agency, as you know, everything that comes before you is highly technical. Usually the applicant or their attorney introduces the application, they have their expert speak, they present their application. We always have the applicant go first simply because it's their permit, they're the ones who have the skin in the game. The purpose of a public hearing is also to hear from members of the public for, against, or non-committal on the application. The general batting order goes the applicant, members of the public, and then any rebuttal from the applicant. We always have the applicant close the public hearing. Again, the theory being it's their application, they're the ones who have the skin in the game. Now, a member can be disqualified from a hearing or from deciding on a matter for a couple of different reasons, and we kind of discussed this previously. One is if there's predetermination or bias, if someone is so closed-minded that they cannot render a fair and impartial decision based on the application. In that case, again, this is something that's obviously very personal to an individual, so it falls upon that person to take it upon themselves. But if for some reason a member of the agency feels that there is some reason they cannot fairly and impartially decide on an application, the proper thing to do is to recuse themselves. The other one is a conflict of interest. Again, that's if there's a personal or financial relationship to the applicant or the outcome. The best course, and what we always advise, is if it seems like there might be a conflict of interest, the best thing to do is recuse yourself, avoid the appearance of impropriety. The most important thing is that the public has confidence in the process and in the decision-making and impartiality of this body. Any decision you make must be supported by findings or what is known as substantial evidence. This is a legal term, and it means evidence that affords a substantial basis of fact from which the fact in issue can be reasonably inferred. For our purposes, what that means is there has to be specific evidence. General, non-specific concerns or speculative claims about potential impacts are not considered substantial evidence. A significant potential for an impact is not sufficient. The impact must be likely and adverse, and And again, an impact only on an upland review area, but that does not touch into the actual wetland or watercourse themselves, is insufficient. Any decision you make must be stated on the record. The statute requires this, and your regulations require it. Mr. Gaishel and our office really take pains to make sure that any decision that is rendered by this agency is very well thought out and very well defined and written out so that there is no question as to what the findings are and what the basis of the decision is. And there are certain, pardon me, when you're deciding on an application, you are limited to the evidence that is in the record, okay? That's evidence that was brought in and entered into the record during the public hearing. Once the public hearing is closed, you may not consider any evidence outside the record. There is one exception for this, that is report from staff. What that means is a report from Mr. Gaishel or from myself or our office, but that has to be based on evidence that is in the record. Outside of that, you cannot consider any evidence outside of the record. If you do, if something is brought up during your discussions or your deliberations, and that is a basis for your decision, that can call the entire decision into question. That's the last thing we want to do. Section 10.2 of your regulations, which mirrors the Connecticut Environmental Protection Statute, sets forth 6 factors that you must consider when rendering your decision. That's the environmental impact of a proposed activity, any feasible and prudent alternatives that would cause less impact, the relationship between the short and long-term impacts of the proposed activity, any irreversible or irretrievable loss of the wetland or watercourse that might be caused by the activity, and any mitigation that could lessen that impact, the character and degree of injury to the wetland, and the impacts of any future activities associated with the activity that's being proposed. So you're required not only to consider the proposed activity, but also any activities that are made inevitable by the proposed activity and which would have an impact on the wetland or watercourse. Folks may recall a few years ago, a petition came in for a road. The road was going to be the first step in a subdivision. So clearly, we knew that there was something more than just the road. However, the application was only for the road at that point. But the applicant properly included the layout of the subdivision so that the agency could consider not only the road, but the impact of the rest of the subdivision. So that's kind of an example of that. Now, if you deny an application because you find that feasible and prudent alternatives exist, you have to state what those alternatives are in writing. Now, a feasible and prudent alternative is set forth in 10.2 of your regulations, and that requires you to consider any alternatives that might have less of an impact than the proposed activity. You also have to consider alternatives if a public hearing is held based on a petition. Now, feasible and prudent, those are generally defined terms. I won't necessarily get into those right now. If something comes up to that point, we can certainly go in, and obviously they are very fact-specific based on the specific application. You don't have to necessarily explicitly consider each and every alternative, but it is the applicant's burden to show that its proposal is the only feasible and prudent alternative and that there are no other feasible and prudent alternatives. Again, if you find that an alternative exists, you have to state on the record what it is. Once you render your decision, it has to be published so that it can be appealed to the Superior Court. The thing to remember is any decision you make on an application is subject to appeal. A little bit different also for a wetlands agency is people can do what's called intervening in an application. That is triggered by the filing of a petition under the statute and basically allows anyone to intervene in the wetlands application process. If the petition meets the requirements, and generally they're drafted by an attorney, so they usually do, the interveners have to be allowed to present evidence, but that is limited to the potential environmental impact. When this happens, you're required to make a couple of additional findings. In addition to the decision on the application itself, this is a two-part inquiry. First, you have to find whether or not the activity is reasonably likely to unreasonably adversely affect the public trust in water or other natural resources. If you do, then you have to consider whether there are feasible and prudent alternatives. What constitutes unreasonable pollution? Again, very fact specific, but it has to be something quantifiable. It can't just be a de minimis amount. The appellate court, in a case that our office handled, defined this as a demanding standard that again has to be supported by substantial evidence in the record. Now, just because someone intervenes, it does not expand the agency's authority. You still have to decide the application in front of you based on any environmental impacts. Finally, as members of a municipal board, you are subject to Freedom of Information. This means you are subject to Freedom of Information Act requests, and we do have people in town who will make requests of you. There are two basic purposes of the Freedom of Information Act. That's to allow access to public records, and more to the point for this agency, open public meetings. A public record is defined as any information relating to the conduct of the public's business prepared, owned, used, received, or retained by a public agency. The basic premise is that anything in town hall is a public record subject to particular exclusions. A document also includes electronic communications, texts, emails, IMs, however else people communicate electronically. It's important, and we urge our commission members, and I will urge you again, do not conduct substantive business of the agency via text or email. Technically, if that happens and an email or a group text goes out and it's something more than just, hey, we're meeting at this time, or we move the meeting or something like that, that can be considered an illegal public meeting. So we definitely want to stay away from that. So that is a very brief, basic overview of a very complicated job that you folks have. If you have any questions, I'll be glad to try to answer them. If not, I'm sure we will meet again when there are applications pending.
I actually have a question. So I know that the agency has the right to seek our own specialist for certain applications. How does that process work? Because it has to be done during the public hearing, correct? If we were to say,
or sometimes it's initiated before.
Prior.
Also, yeah. I mean, Gary could probably speak to that better than I
I
can.
think the question is when we receive an application, right, we have to make a determination whether or not to conduct a public hearing or not.
Correct.
Typically at that meeting is when the agency probably should determine whether or not they need professional consultation, right?
Correct.
okay.
Correct.
In which case we would then charge a complex application fee
Correct.
to cover that amount. I guess the question is as the agency moves forward with an application, what may, at that initial meeting when they accept it, appear as though they don't need a public hearing or professional expertise, and the clock starts ticking, and then we need to bring them in. If we're in that 65-day period where there's no public hearing held, how do I guess if we're not held to the statutory time frame because we don't render that decision, it's not automatically approved, we just hear it all out?
That's one way to do it, and simply because there is no inferred approval, we certainly don't want to counsel or be in the habit of just extending things out unnecessarily.
Right.
As with any land use application, the applicant does have the power to grant extensions. So if something comes up during the public hearing where it looks like things are getting in a little bit deeper and the agency may want to consult an expert, you can certainly request an extension of the applicant at the time. Again, they can grant up to an additional 65 days. And again, obviously we don't want to rely on this, but since there is no inferred approval, we just don't want to be in the habit of, abusing that privilege, so to speak.
So does the committee have the right to review a town file on a particular piece of property that an applicant is wanting to do something with?
I guess that sort of depends on what the purpose of the review would be.
Well, to see
it'd
whether
be-
or not there's been applications for that particular property before, and if it was rejected and why.
Well, again, you have to remember that when an application is before you, you're limited to evidence that's in the record. And generally, evidence is put in the record through staff, through the applicant, through members of the public. As a commission member, you certainly have the right to go view the property, things like that. If there are questions about certain things, it's better to direct those questions to Mr. Gaishel or our office, and let us follow up on those. That I would suggest that rather than.
And then, just a curiosity, on the FOIs, where, an applicant can request all of our information regarding the particular situation. If it lists attorneys, I thought attorney to client is privileged.
Yes, that's correct. And again, I didn't want to get too deep in because FOI is its own rabbit hole. But yes, the general rule is anything related to the conduct of a public agency is a public record, but those are, as you point out, subject to certain exemptions and exceptions, attorney-client privilege certainly being one. Absolutely. Okay, thank you very much.
Thanks. All right. Sorry, to move this. Okay. Under new business, the application of the Town of East Lyme Public Works applicant, the application for a general permit to conduct regular maintenance along town-owned public rights-of-way.
Hello and good evening. For the record, this is Alex Close, the East Lyme Town Engineer. I'm representing the Public Works Department of the Town of East Lyme for this application before you. So, essentially a history of this application. Back in 2006 was the last time that the Public Works Department made a direct application for general drainage and watercourse maintenance within the town's right-of-way. This application in 2006 was based on a similar application that the Connecticut Department of Transportation had with the Connecticut Department of Environmental Protection as a general permit. So the same conditions of the general permit of the state at the time were figured and adopted by the Town of East Lyme, were approved, and since then we've been extending that application. As of this past year, the extension of the application has reached its terminus, and so I spoke with Mr. Gaishel and decided to submit a new application on behalf of the Public Works Department. I spoke to our highway superintendent to ensure that the same three criteria would be sufficient, and that he believed that under these same three criteria that we applied for back in 2006, that he could conduct the operations necessarily on a daily basis, responding to emergency situations, as well as conducting routine maintenance without the, as you can imagine, the extensive right-of-way and town-owned property in the various wetlands that it touches. It would be extremely difficult to go and present an application every time routine maintenance in our right-of-ways needed to be performed on our drainage, and sometimes they're also in an emergency situation where a repair needs to be made immediately to the drainage network in order to protect the safety of our townsfolk. So you have before you an application signed by the Town of East Lyme First Selectman Representative Kevin Seary, made on behalf of the Public Works Department. I myself, as the town engineer, will be the erosion control agent, and I am a licensed professional engineer in the state of Connecticut. So on this application, I've prepared a memorandum that discusses the three activities specifically that we are applying for under this request for general permit to maintain the right-of-way. These activities that we are requesting are excavation of accumulated sediment or removal of brush from the inlet and outlet sides of a drainage pipe or bridge, cleaning or reshaping of a man-made drainage way or sediment basin. Again, this is a sediment basin or drainage way that already exists, not a new sediment basin or drainage way that would be proposed. We would provide that under a separate application if need be. This isn't just to conduct existing maintenance. And installation or repair of a culvert or bridge head or end wall. And as I have noted here, I will ensure that on behalf of the Public Works Department that, of course, all sediment erosion and control measures in accordance with the 2002 Connecticut Guidelines for Soil Erosion and Sediment Control will be implemented as needed by our Public Works Department. I've also included in the application the notice to our own local water health authority, as well as the Department of Public Health, the necessary aquifer protection information for the 3 aquifers that we have in town. So this is supplemental to the general wetlands and watercourses that are within the right-of-way, but Brides Lake, Gorton's Pond, and Dodge Pond. You can see that I've attached the emails of the submission and the submission itself, and then lastly, there's just a statement on the fees for the application being waived from municipality. That concludes the presentation of this application. I'm happy to answer any questions that you may have on it.
Does anybody have any questions?
So to be clear, this is nothing more than what you're doing now and have been doing since 2006.
That is correct. This is standard maintenance that we've been doing since 2006. Our permit has expired. We are applying for the exact same conditions, the exact same activities that we had requested and were approved then.
Were there any new waterways or aquifers in that time period that you had to make application to maintain?
Mr. Gaishel, do you have a record of, I would assume that the 3 aquifer protections since 2006 were the same, but I can't confirm that.
I don't know what they would be. I was just curious.
Yeah, the aquifer protection areas, those are existing per the zoning map. Those have been in place for quite some time, at least since 2006.
Mm-hmm.
Those wouldn't change unless the zoning commission made a change to their map. As far as new basins or drainage ways, I would have to research our files to see what applications the town made and if that included basins or drainage ways. But certainly that can be something that we can get to if you're interested.
Fine.
That's a good question. Any discussion? All right, thank you.
Okay, thank you for your time.
Do you want to discuss this, or would someone like to make a motion?
I don't see that we need a lot of discussion. It seems like one of the easiest things we should do.
Agreed. Just have to throw it out there, though.
Yeah, no, I hear you. Well, I move that we approve this application.
Do I hear a second?
I'll second.
All those in favor?
Aye.
Everybody? All right, thank you.
Great. Anything else? Thank you, and have a great evening. Good luck with the rest of your meeting. Carrie?
Thanks. It's nice to meet you.
Thank you.
All right, next, under new business, we have the application of Paz and Construction LLC, application to maintain 2 Connex boxes, steel shipping containers to store equipment. Alfred H. Smith, owner of 297 Boston Post Road, Assessors Map 31.1, lot number 57.
Good evening, members of the commission. Ted Harris, 351 Main Street, representing the applicant this evening. Just a little background, as the commission knows, there was a previous permit for processing materials on the site. That permit has expired and we are no longer processing any materials on site. The remaining materials are vegetated and there's additional silt fence around the base of the pile. What we're proposing tonight is to store have storage in 2 Connex boxes, 12 by 40 feet. These boxes have been in place for 2 to 3 years, and arguably we're outside the 100-foot upland review area, but given the fact that this increase, we decided to come forward to this commission. So there's no doubt that we could permit these things. This is entirely within the upland review area. They are located on a gravel base, and other than that, the only activity on site is parking. And you can see the boxes located on the plan approximately 130 feet from the water's edge. There may be some wetlands along the water's edge, which is why we're before the commission, because they may or may not have been within the 100-foot upland review area at the time they were placed. So we're trying to make sure that we're completely permitted.
Okay, so you're not, these are already there, they're.
That is correct.
Okay, they're outside the 100-foot, but within the 300-foot, so you're applying for a permit for those?
Correct.
Okay.
So when,
I'm corrected. They are within about 50 feet of the wetland. There is a
Oh.
little patch, I'm corrected.
Okay.
so when were the silt fences put in? I mean, last time we were there, they weren't there, so.
Part of the other permit, they require us to do it, and then we would just, you would update it.
Yeah, they've been there for some time,
Okay.
in conjunction with the prior permit that was in place.
Oh,
And they've been updated as needed.
Because I know we've discussed this property a couple of times, and there are some of old, there used to be a camper, and there's construction equipment there within the 100-foot. It's kind of, stuff is kind of growing up around it.
Are they being used currently?
Just a couple pieces that aren't, that we gotta get rid of everything else.
Other than a couple pieces of equipment, everything else is being currently used.
So, do you know when the, I think your father-in-law said that they were antiques. They looked,
They're antiques.
Okay.
I mean, is there any way that you could remove those?
I'm trying to get them to remove those.
I'm just curious, on the application, there were a few things, on number 5, it says the property contains, but it doesn't indicate anything.
I'm sorry?
I'm looking at the application. So on number 5, nothing is circled as far as, water course. You're right next to a aquifer.
Well, I believe I had circled water body.
Oh, mine doesn't show anything, I don't know.
It might not have gotten translated when my secretary typed it up.
Oh, and also the soil scientists, since you described the soil types, do you know who this soil scientist is?
I pulled the soil types off the GIS, and given the fact that we're so far in the upland review area, that I didn't think it was necessary to have a soil scientist.
Yeah, in number 15, it says, is this property within a public water supply? That wasn't responded to either, but I'm guessing, Gary, that it is, right?
In the public water supply watershed?
Yeah.
I believe it's within the
Yes.
watershed.
Okay. And I don't know, Gary, has there been any wetland violations? I know we've reviewed this property a number of times.
So I had initially issued a cease and desist, whereby the agency, we failed to hold a show cause hearing within the 10 days of the issuance of that order, so thus would be violating the applicant's and property owner's due process, so basically that the order would fail. As we discussed at the last meeting, I was going to reissue the order, but in discussing this with the applicant, they chose to go forward with an application as a remedy. As we've heard Mr. Harris say, that the previous permitted activity where we did not renew that permit, which was the stockpile of 100 cubic yards of material, that activity is no longer going to be conducted, or the processing of that material. My discussions with Mr. Harris today indicated that the majority of that stockpile has been grown and vegetated, and I don't know if
That is correct.
speak further to that. So as you've just heard, So if the pile is stable and not moving, as long as as long as they maintain that, I mean, it's not going anywhere. At the same time, I think I don't know if there's silt fence around it currently, or?
Yes, there is.
So with silt fence currently around it, and if the pile is vegetated, it should be relatively stable.
And also, there is additional silt fence along the perimeter of the property near the wetlands in strategic places as well.
I also discussed with the applicant the equipment and the outside storage of that material. In our discussions, basically, the majority of that equipment are vehicles, trailers, and they're registered. So with the exception of some of the larger equipment which is used for construction, aside from the trailers which don't typically carry registrations, the applicant indicated that they do have to maintain them, and I think report to was it motor vehicles that they're up to.
They have to be inspected annually.
So, although I don't have any oversight over that, certainly that's something that the landowner and the property owner has to continue, and I guess note that. So if vehicles are coming in and out, I don't see how that necessarily violates the wetland regulations. I would say the primary use on the property is a single-family residence. These are secondary activities, possibly. I just note it's all one piece of property, which contains a house, a garage, and a lawn area, and now 2 Conex boxes as accessory structures, so the storage of equipment. As far as the use and the continuance of that use, that's a zoning matter, but whether or not, sounds like, based on the application, it's 2 Conex boxes for the storage of equipment. There's going to be the outside storage of some materials and equipment as well, so machinery primarily.
I have a question. Just because it was like pointed out that number 15, where it says, is this project within a public water supply aquifer protection area or watershed area, which it would be considered because it's right on the lake. So then it says, if so, have you notified the commissioner of the Connecticut Department of Public Health and the East Lyme Water and Sewer Department? So just for completions, like, it doesn't seem like that part was done. So for the application, wouldn't that have to be done?
Yeah, I would recommend that the application notify the commissioner.
We can do
of Public
that.
Health.
I don't want it to like come back in later and be like somehow, somebody gets in trouble because it wasn't actually
Correct.
the steps weren't followed.
Understood. Agreed.
Can I ask too, like, how long have the Conex boxes been there?
2 to 3 years.
And so they were outside the 100 feet,
Yep, that's our belief, yes.
but
Well,
now,
no, they're within 50,
Within 50, I'm sorry.
yeah.
Oh, they are?
I keep
Were
thinking
those
the water
strong
body.
Based on the proposed plan, it's 134 feet to the edge of water.
Correct.
There's the wetland that extends beyond the edge of the water course.
But there's no wetland delineation that has been done.
Well, there's not by a soil scientist. But I think that area where it says limits of clearing, that's probably pretty accurate as far as where the edge of the wetland is. If you look at the fence from Boston Post Road on the side of the house, you'll see that the Phragmites come right up to it, and then extend around the back. So, pretty confident that
So
that
those
whole...
boxes are pretty much right up to the
Well,
wetland.
as the applicant indicated, it's within 50 feet, plus or minus. I would think they might be a little closer, but
But they are sitting on gravel
right, the area's already been...
with good drainage at that point.
yeah, I mean, I don't see the Conex boxes, I don't see as any different than the storage units that we talked about at the Colton Road application.
very similar in nature
Yeah.
in terms of the size and the square footage, yeah. while they're not pouring a pad to put them on.
Which is probably better from a standpoint of runoff.
Exactly.
Did we get an application for those boxes, for the placement of those boxes? Because I don't recall.
For these,
Yeah.
this is it.
Yeah,
This is,
but they've been there for 2 years.
correct. So they would have been in violation, and that's why, based on my discussion with the applicant,
So we're
what I-
doing after the fact?
this would be an after the fact. So if I was to issue an order based on the conversation that I had with the applicant, the applicant's attorney, the only thing in violation were the Connex boxes. The other activities going on there, I don't think I can actually determine that they're in violation.
So we're before the commission to
As
try to
such.
straighten this out, basically.
They're bringing the application forward for them.
And I do appreciate that you guys are here, because we've had these discussions for a bit. You know, the application, I wish was maybe filled out a bit better, seeing that there's things that are not even circled and it's not even signed. So the, no, the last page is
That's the last
is there another application? Because there's nothing circled or it's not even signed.
The first page is signed, but not,
Nothing about, you know, the property contains watercourses, wetlands, as we discussed, that's not circled. You know, is it within a public aquifer protection area isn't filled out.
Yeah, the original document, the last page has to get signed. Well, the applicant's here, they can sign it.
Yeah,
Sure.
I just,
Execute. Well, that being said, obviously, those are deficiencies in the application. We don't have to render a decision this evening. We have 65 days to render one on the application. We give the applicant the opportunity to provide that information,
We can do that.
or withdraw, reapply, and I don't know that that's going to save
yeah,
any time.
no,
or-
I
so
agree.
could they, if we just don't render a decision, could they come back and just like
Yes,
Right, yeah.
we
revise
certainly
it so
can.
that it's more complete?
Absolutely.
Okay, without having to start
I
the
would-
process
yeah,
over.
Yeah.
Now would be the time to convey your concerns and let the applicant know them so that they can address them, so that maybe at the next meeting, we can move forward with a decision.
That's fine. We will,
I personally, I'm okay with I would be okay with the boxes being there. I just,
I agree.
for it to be
To be complete,
I agree.
complete, I
exactly.
just
I
feel
agree.
like the application needs to be
Yeah.
signed and all of all the lines need to be filled out that are supposed to
And
be.
recognizing these are existing structures, if you could just highlight where the little patch of wetlands are on the map, if you could just do that so we know
Sure.
relative to where this is.
Like just, yeah,
That's
estimated
just-
wetland, you know, 'cause
Yeah.
it's not, if it's not delineated, you can't really put it, but if you just say like approximate area of wetlands so we can see.
Yeah.
So am I right in being new to the agency? I'm assuming that you've had site visits in the past.
We have, yes,
Okay.
but it's
So-
been a while.
We could
With
have
the
one next
application,
month.
you could have one next month, you can put it on the agenda,
Sure.
and we can walk it. You can also walk at your leisure.
Or I can just, I can just go out and drive
We
by.
just need to notify the applicant
I-
during
I-
business hours. And
I don't know that I need to,
Yeah.
ransack your yard, but, I mean, I could go out and drive by and just
You
see.
can drive, yeah. So if
I'll
you'd
do a
like to-
drive-by.
We can certainly put it on the next meeting agenda for a site walk. If you-
Sure.
Yeah, I
I
think
think
that would be
a
good.
good idea.
Yeah.
So we'll see you next meeting.
And in the meantime, you'll complete
Yes,
the application and have it
I'll-
for us.
I'll complete the application and refile it.
Thank you.
Our next meeting is April 5th, is that correct? I believe that's right.
Yes, April 5th.
Yeah.
April 5th. Regular scheduled meeting.
Yep, okay,
Thank you very much.
okay, thank you.
Thank you.
right, moving on to pending applications, none. Old business, none. Chairman's report. Well, I guess we can get in discussion to this when we talk about the draft regulations. So I just wanted to discuss those a little bit. So we'll move on to the Inland Wetlands Agent Report.
I have not issued any permits in the last couple of months, but I did have 2 hit my desk this morning, so I have not even looked at them, but I think they're administrative approvals for, I'm not even sure what they're for, but Jen indicated they were administrative in nature. So in terms of wetlands, things have kind of slowed. Looks like I may be able to get a paid internship coming up probably in May when the semester's over. So that looks promising. That's all I have to report at this time. I did send out some correspondence. I made copies of a FOI request.
Yeah, can you elaborate what that's for?
In regards to that, I will just say it's for your notification. It was requested of the commission, this information. I would hold tight until the town retains counsel, because there are items in there that may be subject to attorney-client privilege. I don't know myself specifically, so we're in the process of securing.
What is this in regards?
Yeah,
like,
that's what.
what
Do you know what
is
this
this
is?
for
For?
a certain
Is this
specific
Brightwood?
application, or
No, I'm not sure what it's in reference to with specific application. I would just note who the individual requesting it is. I believe it may be in regards to their applications that we previously reviewed, although I think it was 121 Upper Patagonia Road, we have that appealed. So I suspect it's relative to that.
Discussed in executive session, so basically it can't be disclosed at this point. However, just regarding this FOI request, you really, if you read through it, you'll see, but we should not erase or delete any, emails pertaining to the Wetlands Agency, any communications at this point, because those are all basically foiable. And as Gary just said, the attorney will tell you, tell us what you need to disclose.
So as of now, I would just, if you have electronic communications regarding any of those matters, is put them in a folder, or copy them to a thumb drive, and just hold on to them, don't lose them. And then once we get further clarification, we'll show them to our attorney, whoever that may be, and they can determine what's attorney-client privilege and what's public information.
Yeah, the period it looks like in here is from December 1st, 2020 through the date of production, which is February 15th, 2022. However, on a different page it says December 1st, 2021. So
Yeah, there's some
discrepancy
discrepancy. Correct.
in the years on this, so we'll have to get clarification
On that.
One of
So,
them typo.
I mean, as it pertains to myself, I just go back to 2020 to be conservative, because I know I'm going to have to do the work at some point. That said, we've received, this is our 5th FOI from, I guess, parties that this attorney has represented, I think, or maybe the 3rd. Anyway, I think we may have already answered some of this as well, so we'll have to look at that too. So.
And just so everybody here knows on this side, because this has happened in the past, you could potentially get papers served at home, but our town attorney represents us. So don't contact their law firm, go through our town hall, and our town attorney will represent us. So
Yeah, I would recommend, if you have to, you can go through Kevin, first selectman,
yeah.
or myself. Either's fine.
Yeah, we suggest you go through Gary, and then Gary can contact Kevin and just all of.
Yeah, but we're not on our own. Like, we don't have to go reach
yeah,
out to
I
them.
remember last year it was like we got these papers and we're like, oh
no.
my gosh,
What do we call?
what
What
did
do
I
But
do?
the takeaway is, if you're going to be sending emails, make it
Okay.
So, Gary, getting back to applications, for a couple months you had given us a list of the applications that you had approved.
Yes.
Could we go back to doing that again?
Absolutely. Yeah, I just haven't approved any recently, so if there's no change in the list. So, but
Yeah,
yeah, I can certainly do
because
that.
it's surprising, because I know you said, you know, when we increased the upland review area to 300, you said that we were going to be inundated with applications, and in all honesty, we haven't. So
The agency hasn't, I have.
Yeah, I think right now it's just like,
So, because we're not
But- and
getting,
that's-
we're not seeing them though.
Just in the last 2 months.
Yeah,
But I printed lists, you've had them, I think I,
yeah, a couple
But-
times you did. Yeah.
yeah. But yeah, I'll be more than happy to print that out for you.
Okay.
I mean, right now it's probably safe to say there's not much going on because it's the middle of winter.
Well, there's a lot of activity going on because of permits that have been issued, but no one's applying right this minute. But as I said, I just received 2 today.
Oh, okay.
So, yeah, that's where we stand.
Is there, you had said that the, I don't know if this is, if we can discuss this or not, but, you had said that there was an appeal for the, Upper Patagonia, like for that property.
Yes, 121, our decision on Upper Patagonia on the
Yeah.
121
When
subdivision.
they appeal, when somebody appeals it, do they like explain why, you know, or like what they feel was wrong?
So,
or
yes, when an
That's
applicant
it.
takes an appeal, when they file the appeal, they have to file it's like a brief, a complaint, and they go through and make their claim, and this is their argument, that all the things that the town didn't do or did do, or what wasn't done, and why they should be approved. They're making that argument. So, yes, there's that
Did-
document's out there. And
Okay.
so if you'd like to look at a copy, we can do that probably in an executive session.
I was just curious why, what it was that they were unhappy about, but I don't know if that's okay to talk about or not.
I'd have to read through the brief to look
Okay.
at all their rationale.
Because I thought we like approved it, it was just that,
We
little buffer or something that we
approved it with some conditions.
yeah.
My guess is they did not like
Like
all
the
the conditions.
Okay. All right.
Yeah, but we can do an executive session to discuss when that, I don't think anything's really happening with that right now anyway, so.
No, it's kind of, well, we're moving through litigation with Robinson and Cole and the 2 pending matters that they're representing the agency on. I'm not comfortable discussing anything further without an executive session.
Okay.
Yeah.
Does this agency have more lawsuits or pending issues than most other agencies in town?
I would say no, just as many as probably
Just as many.
zoning in terms of appeals,
Yeah.
and just as many as the building official.
Okay, curious.
I mean, but we do, I mean, our appeals are slightly different. I think they add up, they tend to be dragged out and they're longer.
Yeah.
It's the nature of the beast, I guess. So that's all I have to report at this time.
Okay. Well, so that was permits and
Permits,
enforcement.
yep. And then in terms of the regulations, so
Yeah.
if we wanted to have some discussion tonight, but these were the regulations that the subcommittee, prior to the commission taking and changing the regulation from 100 to 300 feet, so I'm just noting that, it's in there as 100. I think the idea was that both Kristen and Mr. McIntyre would work and review and work with myself to modify, review, and edit these, or run through them and see how the rest of the commission feels about them, if need be, or we can discuss them regularly as a whole commission.
So
Or do nothing with them at all. That's, you know.
so is the upland review area to 300 feet?
Yes.
And that's
So
just in East Lyme?
just in East Lyme. As of November 24th of 2021, we've been holding a 300-foot upland review area. That decision was appealed and is currently in court. hopefully we'll get some decision soon. We've had a court date that's been moved twice. There's a tentative one for the middle of March. I have a conflict personally with that one, so I don't know if that'll actually happen. It hasn't necessarily been scheduled, so I don't know. And it all depends if I'm even subpoenaed. I was subpoenaed for the first one, but I don't know that the rescheduling, they'll want me back. So it's very inconclusive.
So, if I may, I mean, we talked a little bit before the meeting, but I thought that originally this was about you receiving applications and determining when the clock starts, when they were complete.
So what I wanted to do is take a look at these regulations versus the current regulations and what's required for application submittal and what constitutes a complete application based on our regulations, so that the idea is that when applications come in, as we saw tonight, that they're complete, and that either I can review them before the commission even looks at them and say, yeah, this is incomplete, we won't accept it. We won't even take your money, type of a thing. You know, I'd like to leave it at that if I could.
So why did you accept this, the one that we just reviewed? It wasn't signed, there was a bunch of stuff that was.
I had not looked at it. They essentially submitted it Friday. It was incomplete then, and then they came in today with the site plan. So technically, the data receipt is tonight, the agency receives it, it's business. So I'm just following the law. We have to take their application, they paid a fee, whether I like it or not. I can say it's incomplete, and based on, I guess, a recent experience with a lot line revision where I was, now granted we didn't have our own counsel weigh in on this, but the opposing counsel said, hey, based on the regulations, Gary, you cannot deny a lot line revision. So they basically went before the planning commission to get the lot line revision approved, and that's just a sticking point in arguing that, hey, your staff didn't violate due process by denying this. Well, I stand corrected. The lot line revision went forward and has been approved, but if it's not explicit in the regulations, I'm just going to accept his application fee and let the agency make the determination whether it's complete or not at this point. But if we can craft a regulation that would allow me to do that safely and not violate someone's due process, that would be ideal.
Yeah, but the application that we just reviewed is just, all you had to do is kind of open it and see that there was a lot of stuff that was blank and not signed.
Correct.
I mean, I'm not quite sure the case that you're talking about, a lot line.
Right. It was a subdivision matter.
Yeah, I don't see apples to apples kind of thing.
Regulatory
Comparison.
wise. What I'm saying here is our regulations, I don't know that they're explicit enough for me to say, I can't accept your application, go away.
But it wasn't signed.
Agreed.
Well, I mean, but the thing we talked about before was, when does the clock start? You know, when they give you a piece of paper that says, hey, I want to do this, and
Today.
it's not like this one we saw today, or is it when it's completely filled out and until and if when it is, you simply say to them, I can't accept this, it's not filled out, there's no check, there's no,
So,
it's not complete.
right, that's not in our regulations. The data
Yeah.
receipt is the day the 30 days, or it's the next regularly scheduled meeting of the agency, or 35 days thereafter.
Right.
There's nothing about whether or not
Whether
I
it has to be filled out. or
filled
not.
out completely.
So,
if
yeah.
it wasn't, like,
You could have written
we
the
could have just
decision,
said,
denied.
we're denying this, come back,
Correct.
but we didn't, we're
Yeah,
giving them,
And I made
But I
that-
think what Gary is saying is that in these regulations, and specifically section 7 and 8, it is not laid out that he has
Right.
the right to do that.
Right, and page 18 has now what's proposed to be,
some language that addresses that, but
yeah.
maybe we can better drill that down. I'd like to review it and go through it and
Sure.
see if we can improve it.
Well, how does zoning do it, or
Same
building?
way.
That's-
They have to accept the application.
Even though it may include incorrect information?
They have to accept the application and make a determination like any other agency that it's complete or incomplete.
as long as they're paying
So I
whatever
think that's,
fee.
so look, what happened today, if they gave us an application, we could have said, we accept your application, but it's incomplete. And then they would have to reapply with a new fee.
Right, so they're
So
gonna try
we're
to,
saying, all right, we'll give you the time to try and correct this and come back.
so they could have withdrawn, that was my suggestion. Otherwise, but what does that do? They're gonna come back with the same paperwork with a sign, doing two things, signing the application and coloring in where the wetland is. So from that perspective, it's, have them withdraw, it's just submit another fee, and the fee was not substantial. But we can do it, at this point we can't, but we could have went that route, but I didn't necessarily see that would just add another month to the whole process. I would think.
Okay, so revising this, the inland wetlands regulations, you're saying with revising it, you would have something specifically saying that it has to be a complete
Application upon submittal to the land use office. And that these items have to be there in order for it to be constituted complete.
I
or
don't know,
accepted.
it just seems like common sense to me that when something is dropped off at your office, it would be complete,
I would.
You'd be surprised, right?
We get a lot of incomplete applications. Applications with site plans on scrap paper sometimes. Really?
Well, that I understand, but the application is black and white.
Yeah.
I would agree that
Could be a little
it's straightforward, and if it's
offensive almost, but.
So I have a question about page 18 in this, the regulations, where it says 7.6. All the red text, is that new text?
that was the new text.
Proposed.
Yeah.
Okay, because, so say this was approved, where it's, so then 7.6E, where it says all wetland boundaries on the subject property shall be identified by a certified soil scientist and located in the field, blah, blah, blah. But, so, that permit that we just saw, we could turn it down because they didn't have a wetland scientist delineate.
Well, you would determine first whether or not it's an intermediate or significant regulated activity.
If you look on page 9,
And so
Okay.
essentially, being that they're coming before the agency, yes, it would be an intermediate activity.
so that way someone putting in a shed doesn't necessarily need to hire a soil
Oh,
scientist
okay,
because
gotcha.
it's broken up
I missed
into
that
minor,
part.
yeah, no,
Okay.
this is definitely something I want.
That's a good question.
Yeah,
Yeah.
it is, and I just really freshly looked at this, that's why I knew the answer to that, but, I think it defines what type of application and then kind of lays out what standards it should be held to
Okay, gotcha.
based on what it's for.
Okay.
So yeah, I know everybody is very busy. If everybody could kind of, Greg and I are going to work on this together. If anyone has any input, kind of reviewing, kind of focusing on the pages, I would say the regulated activities definitions, page 9, 10, and 11. And then as far as applications, pages 18, 19, and 20, I think would be the good spot to focus on. Obviously, there's a lot of changes, and
So as you go through them, being that the upland review area has changed, if we continue to stick with that, just keep that in mind, saying that upland review area is 300 feet, and how
Yeah,
the regulations would apply in that scenario.
right.
So what were the other pages that you listed? I know you said 9, 10, 11.
Yeah, 9, 10, and 11, and like you said, as far as defining a minor regulated activity, I think it is important to consider the 300 feet, so we may want to consider adding some words to redefine minor. And then pages, is it 18, 19, and 20 are the application, what constitutes a complete application for the most part. It still doesn't say signed, maybe we should.
Maybe we should have, signed.
Take an application and go 1, 2, 3.
Yeah.
Something else that I had said to Kristen that just, I don't know if you want to note it too, Gary, or, but if we're going to go forward revising this, we should probably add how we wanted to have the signage, for,
Yeah.
Yes,
where's
that,
here?
actually, that's in our current regs, but
And not
Oh.
in here.
not in here.
okay.
That's what it.
Because this was,
Are we talking public
Okay.
hearing? Is that-
Yeah.
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 so-
Signage
so
for
the-
public
The
Okay.
hearing.
signage requirement stands as it, in our regs, but, yeah, any changes here have to be melded with this, so,
Okay.
yeah, there's a few steps in here we'll have to make sure we don't confuse ourselves, but yes, note that, and, yeah. The intent here is not to take this and usurp the current regulations. The attempt is to take what's in here and merge them, yes.
All right.
Yeah, so if we could add this to the agenda every month so that we can just provide updates and make sure we're staying consistent, whether it's, in your report or wherever we want to add it, but.
Good.
Okay.
I guess just for clarification, do you want Mr. McIntyre and yourself to continue to focus on this
Yeah.
more
Yes.
so than?
Yeah, that's fine. I don't have a problem with that. I think that's fine.
Yeah. I looked at it. I looked at it this weekend, and then I'm gonna look at it more, and then within the next couple weeks, I'll send you some thoughts.
Yeah,
and
I
we
mean, I
can-
looked at it when you sent it, but I didn't have time to go through it in detail, but I certainly will this week.
Yeah. Perfect. Okay. Yeah. Well,
If you guys want to meet separately, or you can do a Zoom or something.
Yeah,
we'd
could do
be
that.
happy to do that and set that up. Just let me know.
Sure.
okay. Okay.
Just, I know this is completely out of order, but I just remembered. Do we have any identification of alternates for the Inland Water Agency?
I have, excuse me, two potential alternates for you.
Oh, good.
This is Diane Berger and Nancy Colal, so I wanted them to come see and sit through the meeting and see if they're interested in joining as alternates.
Welcome.
Oh, great.
That's why we're sitting there listening to everything you're saying. And that's why I was happy that Attorney DeMarco was here to kind of explain everything, so that's why I was really happy that they were able to come.
Excellent. That's great.
Would they
Yeah, we're
like
having
to-
a lot of fun. You should definitely join.
Go running,
Did they get a copy of this?
No, I have extras here.
Oh, do you? Okay, because I think if you're planning on coming back again ever, this would probably be something you'd want to do.
Yeah, so also, I handed out,
I'm gonna be in Disney.
That's awesome.
so May 2nd, I've asked Bruce Hyde from the Yukon Clear to provide a land use basic training. So it'll be a little more in-depth than what Mr. Zamarka went over, but it will touch on that. But it'll also provide you some knowledge on both the planning and zoning aspects of land use, which I think are integral to doing this job.
And then
So-
there's the Yukon course that,
In addition, there's the Commissioners Training Program, which is also held online through the Clear Web Center. So I encourage you all to pursue that, and it's online free training. With that, I would note that Darcy Winter, she works up at the DEEP, Inland Water Resources Division. She puts together the Commissioners Training Program, is responsible for conducting that. She's offered to come down to East Lyme if everyone on the commission takes the course. So, if you have any questions, so, but we might get her presence through Bruce and Clear, and so I'm working on that.
What if you've already taken it? I took it a long time ago.
You already take it, you don't have to take it again, but it's out there. If you want a refresher, feel free.
Is this like the 10-hour training?
I was gonna say, ask how many
Or
hours
eight,
it
yeah, is that a really long?
I took it, I think, at UConn, which actually went up here.
Oh,
I know when I did it, I had to go attend 3 sessions throughout the year. It was an all-day course, and it had to be completed within the calendar year. And if it wasn't, you didn't qualify for the certificate. So, needless to say, when I interned with Darcy and actually put the program together, yet I only attended 2 of the seminars, not the third, so I had to wait an entire year to get a certificate.
but that's what I did online, right?
Yes, that is what Mr. McIntyre did online. I believe our recording secretary has completed it online. Dave Schmidt, who used to be on he did it online. I believe he completed his prior to COVID, and then with COVID, the online portal closed and it reopened with UConn. So it's back up online and available. And,
Karen,
yes.
what, I thought I read or heard that there was going to be some required training for, in the wetland commissioners?
Yes. So in the last legislative session, it requires mandatory training for commissioners. What that looks like, the criteria for which, we don't know. We're waiting on OPM, Connecticut State Office of Policy and Management, to tell us what that criteria will be and what the requirements will look like, et cetera. So until we know that from OPM, but I think they're getting close to rendering some sort of report on it. I think last I saw, the Council of Governments will be getting, I think, that first and disseminating it to their towns. Work in progress.
Great, thank you.
So is that-
Do you know?
Are we commissioners? Is that what?
Yeah.
Oh,
Yes.
okay.
Do you know if this will be like recorded, that somebody could watch it after the fact?
Yeah, it'll be in this room, so we'll have the ability to record. So we can
Oh,
try
yeah.
to do that as
You can
best
do
as
that.
possible.
too.
If you don't mind.
She's gonna be away.
I'm gonna be away, so.
Oh, I'm sorry. Yeah, what we don't have right now is the technology to interact with the Zoom participants, but my understanding is being acquired. And then we gotta install it, so, but right now, we
As
we
long
can.
as it's, like, if I could watch it the next week,
just
that's
listen?
fine.
Sure.
Yeah, just listen.
Yeah, you get a free pass that
Yeah.
day. Disney or East Lebanon Wetlands.
Tough choice.
Any correspondence?
Other than the FOI request, no.
Okay. So on that note, anybody else have anything they want to bring up? Everybody good? Do I hear a motion to adjourn?
I motion to adjourn.
Second. All those in favor? Aye. All right, thank you. Meeting's adjourned.